Okay, it's 12:02, so we will get started. Sorry again that my background looks a little odd. I am Tara. I'm with the Chamber. I'm in member relations. Today for our lunch and learn, we have invited Warren Mouck from O'Neill Associates to give a talk about things that may be pertinent, particularly at this time, having to do with employment law and COVID-19. Warren specializes in labor relations and employment law, administrative law, and human resources planning. And he has taken this time to provide us with some information and perhaps some legal advice. What I will ask is if you have a question, if you could pose it in the chat portion. He has a bit of a presentation at the end. You'll have an opportunity to ask specific questions. If you chat your questions to me, then I will address them to Warren and he'll have an opportunity to answer. Okay, Warren, are you ready to get started?
I'm ready to go. Can everyone hear me okay?
You sound a little quiet. Perhaps I'll turn up my volume.
How about now?
Still a little on the quiet side.
Changing anything?
It's slightly better, yes.
Okay. And everyone who's got their camera on can just go nod like this. Okay, good. It's working.
Warren, I think you need a little bit more volume somehow. You sound muted and not, or quiet.
Okay.
And, you know, for the most part, in a few moments, everyone will be muted for the most part. That's why I asked for the chat portion for your questions. And I also wanted to say, please forgive me if we're clunking around at all, because this is the first time that I'm hosting a meeting myself on Zoom. So should it not be as smooth as it is, I hope you can forgive me. Okay, so Warren, I'll go ahead and share your presentation.
Sure. Is my sound any better? I can unplug my headphones.
Try unplugging them.
How's that?
Far better.
That's much better? Okay.
Yes.
So thanks for setting this up, Tara. I appreciate it. Thanks to you and Charlotte Robinson, President of the Chamber of Commerce, and for everyone who's attending. So what I've got here is a PowerPoint presentation that I've prepared on a few of the common topics. The questions that I'm asked most frequently about issues related to COVID-19 and employment law from both employees and employers. I've got these questions, but I'll go through the topics that I've set up, and then if anyone has questions, whether they're related to my presentation or not, I'll try and answer them. But I would prefer a question and answer format because it just is a bit more engaging and it adds some benefit to you. So Tara, if you want to go ahead. So these are the 4 topics that I've got, and I'll give you the overview. Just so you know, when I'm talking about temporary layoffs, I'm talking about layoffs in the context of non-union employees who work for provincially regulated employers. So in the case of this presentation, we're talking about employees who are subject to the Employment Standards Act. Federally regulated employers have to look to the Canada Labor Code to decide, you know, what are the employment obligations they have. Federally regulated employers are things like airlines, telecommunication companies, First Nation, band offices. Those entities are usually subject to the Canada Labor Code, not the Employment Standards Act. The other issue is employees who are unionized. Pretty much everything to do governing their employment will be in the collective agreement. So anytime you have a question about the terms of an employment for unionized employees, your first stop is a collective agreement. So this focuses primarily on non-union employees subject to the ESA. The other exception is employees in the construction industry. That's a whole different can of worms. There's a number of different exceptions that apply to construction industry employees. I can answer those questions later, but there's certain exceptions that apply to that. So I'll talk about temporary layoffs. I'll briefly touch on the Canada Emergency Wage Subsidy. All of the information on that program, which is administered by the Canada Revenue Agency, can be found online. I've just got a couple of slides on resources to get you there. And the Chamber of Commerce has also put out a link to a calculator If you're planning to apply for that wage subsidy because you've had a decline in revenue because of COVID-19, there's an online tool that will tell you what you can expect to get back in terms of your subsidy. The other issue is, what does a safe workplace look like when my employees do come back to work? And what are my obligations under the Occupational Health and Safety Act? Again, that's a provincial statute. The Canada Labour Code has a regulation on occupational health and safety for federally regulated employers, but generally speaking, the obligations are going to be pretty similar. The other question is about unpaid declared emergency leave. So employees who are going to be off work on a job protected leave because they have, they've been infected with COVID-19, or they've have to care for someone, or they're in quarantine because it's suspected. So there's an unpaid declared emergency leave. That's new in the Employment Standards Act. I'll talk about that last. So the starting point for temporary layoffs is the Employment Standards Act allows for layoff. Am I getting some feedback there? Everything's okay?
Sounds good to me.
Good with you? Okay. So the Employment Standards Act provides for layoffs, and it discusses what constitutes a temporary layoff, and it authorizes layoffs in certain circumstances. So a temporary layoff, generally speaking, is a layoff for a period of up to 13 weeks in a 20-week block. So if an employee is laid off for less than that period of time, the Employment Standards Act allows it. The tricky part about this is that while it's authorized by the Employment Standards Act, most non-union employees don't have a provision in their contract that allows for layoffs. So virtually every collective agreement has a layoff provision. That's why unionized employees can be laid off and recalled in accordance with those terms. In most cases, many non-union employees haven't been laid off before, and it hasn't been expected. You're either going to continue to work until you retire or resign, or the employer is going to end your employment with cause or without cause by terminating you at some point. So this idea of layoffs is not really known to non-unionized employees. And prior to COVID-19, there was a general rule that you can't lay off a non-union employee because that would be a breach of their contract, or in other words, a constructive dismissal. So there was an article published recently in the National Post. It says, laying off a non-union employee is illegal. I would say that it's not illegal to lay off a non-union employee, but it may be a breach of contract. And employment law, when we have a breach of contract, we call that a wrongful dismissal or a constructive dismissal. Basically, when the employer is no longer intending to be bound by an important term of that employment contract. And the most important term of any employment contract is you show up for work and I pay you wages. So there may be an issue there. Now, if employees agree to the temporary layoff, or more importantly, if they don't protest, then they've acquiesced to that change. And if they don't come back and challenge the layoff, then their opportunity to claim constructive dismissal may go out the window. The other part of it is many employees are not going to want to claim constructive dismissal because presumably there will be a job waiting for them when they go back, meaning that even if they had a valid constructive dismissal claim, the amount of termination and severance pay that they might receive will be substantially reduced because they have that opportunity to go back to another job. So I guess the bottom line is, when you're talking about layoffs, there is a slight risk that you may have a constructive dismissal, but it may be necessary in the circumstances. You may have no other option. And in my experience so far, the majority of employees are not going to challenge that because they're not going to want to lose a potentially good paying job over this blip in time. There are other options too, because employees who are laid off, provided that they've worked for a minimum number of hours, are generally entitled to employment insurance benefits. So they're going to recover a portion of their wages. And my colleague, Haley York, actually prepared an article on work sharing programs. And so Service Canada also has information on work sharing. Basically what work sharing is a situation where you have a reduced amount of work and you can divide that among employees, and they can do that work and also collect EI benefits such that they may be earning almost their entire wage in a situation where there's a slowdown like that. So these are the provisions of the ESA, just summarized in my words, of what constitutes a layoff. So a layoff of not more than 13 weeks in any period of 20 consecutive weeks, that's a temporary layoff. You can have layoffs for longer than that, more than 13 weeks in a 20-week period, if it's less than 35 weeks in a period of 52 consecutive weeks, if certain conditions are met. So if you're continuing employee benefits, if there's an agreement between you and the employee, and this goes back to the employment contract, if there's an agreement to lay off for a longer amount of time, you can do it that way. Or if the employee has another job and makes up their earnings there, then you're going to be allowed to have a longer period of layoff. And Tara, if you can move forward to the next slide, the question is, what constitutes a layoff? An employee doesn't need to be off work entirely to be laid off. The definition set out in the Employment Standards Act of a layoff is when that employee, generally speaking, earns less than half of their wages. So for an employee with a regular work week, if they're earning less than half of what they would earn in that regular work week, they can be considered laid off. And if it's a part-time employee, you look at their average earnings over a period of time. If their earnings going forward are less than half, that's generally going to be a layoff. Just my last comment on the question of layoffs. If you lay an employee off for longer than the Employment Standards Act allows, that can result in the termination of that employee's employment contract, and it may trigger termination and severance pay entitlements. Termination and severance pay are two different things, and I can certainly answer questions on that afterwards. Termination pay is notice of termination. So it's you giving the employee notice that the job is ending. Severance pay is a different thing. It's an acknowledgement of service for long-serving employees. So employees who have more than 5 years at an employer, and the employer has a payroll of more than $2.5 million annually in the province of Ontario, that employee will be entitled to severance pay if their employment is terminated. So for small and medium-sized businesses, the Employment Standards Act is not going to require severance pay to be given to an employee, only notice of termination. And notice of termination can be given by working notice or pay in lieu of notice. So if you're ending someone's employment, you can tell them that their employment will end at a fixed date in the future. That's working notice, and they continue to work during that notice period, as opposed to pay in lieu of notice. If you say, okay, today's your last day, I'm going to pay you for that period otherwise. And the decision whether to give working notice or pay in lieu of notice depends on the circumstances, why that employee's job is ending. So those are some comments on layoffs. And again, I'll answer more questions about that at the end of the presentation. This is on the Canada Emergency Wage Subsidy. I'm sure pretty much everyone has heard about this, so I won't spend a lot of time on it. The way that the federal government is rolling this out now is that you may be eligible for a subsidy of 75% of employee wages for this 12-week period for up to 12 weeks, and that period is March 15th, 2020 to June 6th, 2020. And so, you know, the goal of that program is to allow you to rehire workers previously laid off as a result of COVID-19, helps prevent further job losses and better position you to resume normal operations following the crisis. And the rationale there is when you do lay off an employee, there's inevitably some employees who just won't return. They've decided, okay, I'm going to look for something else. So there's always risk that just because you lay someone off doesn't mean they're going to agree to be recalled. That it may result in resignation, and historically that's what happened. At least a percentage of employees will not return after a layoff. So I've given you some links here, and you can access this PowerPoint presentation if anybody wants. I can send it to them afterwards. But there's a couple of key things to bear in mind. If you think you're eligible, you may as well apply. That would be my recommendation. The key point on eligibility is you have to be an eligible employer, which includes an individual, corporation, basically any business entity, but it doesn't include public institutions. So municipalities, colleges, universities would not be eligible. the broader public sector, nonprofits and charities would be eligible. All of the eligible employers are listed on that website. I think the more interesting aspect of this, though, and something that's more important to pay attention to, is the eligible revenue reduction. And so I can point you to the website there, but basically there's an eligible revenue reduction, and it looks to two methods of determining your revenue reduction. You can either compare your month to the same month in 2019. So if your revenues in March of 2019 were 100,000 and now they're 50,000 for March of 2020, you're going to have an eligible revenue reduction. Conversely, you may have a different type of business, you may have a newer business. You're allowed to look to January and February of 2020 and comparing March, April, May, June. So if it's more favorable to look at January and February for calculating it, you can do that, or you can look at the corresponding month in 2019 to calculate it. But once you choose which way you want to calculate your decline in revenue, you're stuck with that. That's my understanding of the program. So just bear that in mind, and by all means, Google the Canada Emergency Wage Subsidy. Going to move forward to occupational health and safety issues. Was there another slide before this that I missed?
May have been worn.
That's
I
okay.
apologize. If you want to address the slide before this prior.
Don't worry about it.
Okay.
The only thing I think that was on the previous slide that is important to keep in mind is there's a number of employers that are closed right now. They haven't opened. We've got Section 25 of the Occupational Health and Safety Act gives a very vague statement that an employer must take every precaution that's reasonable in the circumstances to protect employees. And that was intentionally vague to leave that burden on employers to figure out what is reasonable in the circumstances. It also sets out a number of key things that employers must do. So, you know, in my opinion, I think personal protective equipment is going to be key in the months as we talk about reopening and businesses reopening. You'll see if you've gone to grocery stores or the LCBO right now, they've got personal protective equipment in there, sanitizers, that sort of thing, shields. When we talk about what's reasonable in the circumstances, you know, it's going to be between the employer and the employee to determine, okay, what do we think we need to make a safe workplace? If they can't come to an agreement and a Ministry of Labor inspector comes in, that Ministry of Labor inspector is going to make that call. But generally speaking, if you're looking at, if you're in retail and grocery stores and LCBOs are able to have, you know, a protective shield and that sort of thing, I think it's going to be a strong argument from the employee side that they should have some similar precaution in place. The great thing right now is you see that businesses are getting creative in the way, you know, particularly retail, in the way that they're able to distribute products. It's been a hard time already for brick and mortar stores. I expect that that's probably going to continue, and you know, this is only going to further support online and that sort of thing, distribution by that means, but we can talk about that later. In any event, that's the most important thing to keep in mind, is that it's case specific. It depends on the business that you're in to determine what's going to be an appropriate way to protect workers from particularly contracting COVID-19. There is, I think, a psychological aspect to that as well, in that even if you're in a low risk situation, workers feel they need PPE and gloves, it's probably still going to be reasonable to provide those, and a reasonable request to have them, even if there's a relatively low risk of transmission, depending on the type of work that you're doing. On that point, you know, the Occupational Health and Safety Act contemplates cooperation between employees and employers. Employees who are able to go to work have the right to refuse unsafe work. This is sort of an unprecedented time to consider what is unsafe work, but there are inevitably going to be employees who say, I don't feel safe because I think I'm going to contract COVID-19 because of the way you're making me do my job. That again is going to be something that's case specific, but you should bear in mind that the Occupational Health and Safety Act allows for work refusals, and there's a work refusal procedure in the OHSA, Section 43. if the employee has a legitimate, keyword legitimate, concern over their health and safety in the workplace, they can refuse to do unsafe work. The employer then has an obligation to consider that refusal or the reason for the refusal and work with the employee to try and develop a solution. If there's no solution, that's again when the Ministry of Labor may come in and make an order or determination on what's going to be safe in the workplace. The key thing to bear in mind about this is, and where people may get in trouble, is that as long as that belief is legitimately held, whether or not the actual risk is legitimate or there is a legitimate risk, if it's an honest belief, the employee's probably got a reason to say, I don't want to do the work, and it's not open to the employer to punish or discipline or dismiss or suspend that employee because they exercise their rights. That type of response is going to cause more hassle than is necessary in the circumstances. So I think it really calls for some collaboration to avoid that type of situation. Last point I wanted to talk about was unpaid declared emergency leave. So this is distinct from layoffs, and I've had this question from employers. This is an amendment to the Employment Standards Act that was made by the provincial government in, I think, the middle of March or the end of March. And it allows for a job protected declared emergency leave that's retroactive to January 25th if there's a reason that the employee needs to be out of the workplace as it relates to a designated infectious disease. If you go to the next slide, you'll see the designated infectious disease includes the three. We've got SARS, Middle East Respiratory Syndrome, and the coronavirus. So those are enumerated. The reason for the absence needs to be related to one of those infectious diseases, and it needs to be something that would cause the employee to have to stay home. So, you know, for example, if they had to travel and their public health has said you have to stay home, you have to self-quarantine for 14 days, then that's what this leave is designed to protect. Now, this leave is distinct from a layoff because the Employment Standards Act is designed to protect employees and give them those protections. A layoff is when an employer does not have work for that employee to perform and they get sent home. So that's the key distinction there. It's not open to an employer to impose this leave on an employee. It's something that the employee takes. I think we can go to the next slide. Okay, well, that's it. So lots to talk about there, built into a relatively short time, but I did want to take a lot of questions. I expect there'll be some. Tara, do you see anything there?
Okay, I'm just checking now. I do not see any questions in chat as of yet. If anyone has any questions, please feel free to ask.
Well, that's good. So I know that my presentation was perfect and it's covered everything.
Yeah, I have one.
Okay.
This is from Susanna. If you already know a temporary laid off employee is not returning, in this case, they have left the city. Do you mark them as quit at the date that they tell you this, or after the 13 weeks has expired?
Okay, so the ideal situation there would be to get confirmation from the employee about their intentions. So usually you have to communicate, because for an employee to have resigned, the rules around resignation is that a resignation must be clear and unequivocal. So I think in a situation where the employee just disappears and doesn't communicate with you at all, that would be job abandonment. But I mean, if they've been laid off, technically their position would be terminated at the end of the temporary layoff period, unless you get from them a resignation, ideally in writing. If it's not in writing, then you can make a note to yourself, say, okay, I talked to Bob today and he said that he's quitting. That would probably be sufficient evidence if employment standards officer or employment insurance ever had to ask you about it. But that would really be a job abandonment if they just don't communicate with you and they don't talk. So in which case it's the same as a resignation. And if you really want to get into it, it would be a cause to terminate your employment because you just haven't communicated with the employer about your intentions.
Perfect, thank you. Is there anyone else that has questions that they'd like to pose? I've got one. Do you know what it is? What is the definition of revenue according to the CRA? Also, if an employee works by commission, if their commission diminishes 50%, like or more, is that considered a layoff?
Yeah, so actually the website from the CRA talks about what eligible revenue is. Eligible revenue generally includes revenue earned in Canada from, and sorry, the question was about the definition of what constitutes revenue. Eligible revenue generally includes revenue earned in Canada from selling goods, rendering services, and others' use of your resources. And so the statement there is that you use your normal accounting method when calculating revenue. You can use the cash method or the accrual method, but you must use the same approach throughout, and that talks about generating revenue. So those are the three, I guess, directives from the CRA on what constitutes specifically revenue. It's from goods sold, from services rendered, or from others' use of your resources. So that would be if you had like a service or some sort of Chamber of Commerce, for example. If you were using Chamber of Commerce resources and there was a charge for that, that would be an example of revenue under that definition.
So in terms of commissions, that would be included.
Yes, it would. Yeah.
Okay, that's how I gathered that. I have another question. It says, how can an employee prove legitimate concern over safety on the job or a refusal to work? For example, a worker who has been working in a retail essential service business but is afraid to go to work each day, despite the employer doing their best to supply PPE and safety measures.
Well, I think that the fear would have to be a legitimate one. If you have a group of employees, if you've got 20 employees and 19 of them are going to work and doing their job in what they perceive to be a safe way, I think objectively that person's concern is not reasonable. And that's the analysis that a health and safety inspector at the Ministry of Labor would undertake. Is this person's concern a legitimate one or a fair one? Because I can say, anything is unsafe, but that's just my opinion. And that's why the question is it a legitimate concern and is it a reasonable one? Because if it's not reasonable, then that's the analysis that's going to be undertaken.
Okay.
And I would look to other industries too. The ones that are operating right now are a good example of what is a reasonable, precaution in the circumstances.
Okay, and another question is, do you know if you must issue a record of employment at the end of the 13 weeks to terminate employees?
Record of employment should be issued at the outset of a layoff. So any interruption in earnings, that's when you're going to have a record of employment issue. I think it's a 1 week interruption in the employment for whatever reason, whether it's a layoff, a leave of absence, that type of thing. So you would have already issued your record of employment. I guess if the question is the change in circumstances, so you have a layoff and that layoff becomes a termination, because that 13-week period has lapsed and you haven't recalled the employee, so you've terminated them. If anything on the record of employment changes, then or needs to be updated, then yeah, you would have to issue an amended ROE or a fresh ROE. It would be an amended one, because where you've terminated the employee, you've given them an additional payment, and so you would have to update on the portion of the ROE that cites wages, the amounts paid to the employee. There would be new information to add there. It would also be new information about the reason for termination, whether the employee is coming back or not. Because on your record of employment, you're going to have a layoff. If you're laying the employee off, you're going to have an expected date of recall, and that might be unknown, but you do expect the employee to come back. When you have a termination, you're likely not expecting the employee to come back.
Okay, and I wanted to revisit, there was an additional question in association with regards to like an employee that's on commission. So if a person is on commission and their commissions diminish more than 50%, they want to know if that they are now eligible for employment insurance.
Okay, so it's a bit difficult because it ultimately, the decision to grant employment insurance benefits rests with with Service Canada. So I can't predict with certainty whether they're going to be eligible for benefits. Generally speaking, you will be. And there was a question as well about, the first answer that I gave about an employee who doesn't come back, whether they'll be eligible for EI. EI eligibility, again, rests with Service Canada. Generally speaking, if there's a interruption in earnings that you can't control, it's bona fide, and you've been paying into EI benefits, for example, because some independent contractors don't necessarily pay employment insurance premiums. But if you've been paying EI benefits and there's an interruption in your employment that you can't control, like a layoff, that's what's going to make you eligible for EI. The question about the employee who is laid off and then just leaves town and disappears, that employee may have been able to receive benefits for the layoff initially, but if you quit and you didn't have a legitimate reason for quit, or you didn't quit for what's called just cause, that's the word they use in the Employment Insurance Act, then you're not going to be eligible for benefits because you could have kept working. It's where you have an uncontrollable interruption in benefits that you couldn't do anything about, and you've been paying into the program. That's generally what employment insurance benefits are for.
I have another question for you. The question is, does the unpaid declared emergency leave protect employees who are off because of anxiety or stress over COVID-19? They state that we have taken precautions to set up our governing body, but have allowed employees to take a leave of absence if they feel unsafe. Are they protected?
So that's two different types of things, because and certainly stress and anxiety aren't as well understood in our society. But in my opinion on that is it's a distinct issue from the declared emergency leave. It is in fact a medical or illness related leave. So in those circumstances where the employee has a medical reason to be off work, and anxiety can certainly be included in that. You'd want a medical practitioner to verify that there is a legitimate medical absence. But certainly the employee could be entitled to a leave, but for a different reason, because the declared emergency leave is designed to give people job protection when they can't attend work because of an issue related to COVID-19. Again, if it's a self-quarantine or a mandatory self-quarantine. But certainly that is a legitimate type of leave, but it would be a medical leave. And that's protected by the Employment Standards Act as well.
Okay, so I have another question.
Sure.
Sue says, I have an employee currently laid off. We will probably bring him back next week and take advantage of the wage subsidy. If after the program ends, our business has not resumed to the level that we'd hoped for, can we lay him off again? And will that affect his eligibility for EI?
That's an interesting question. And that goes back to this issue of the employment contract and what an employee has agreed to. So when I talk about employment contracts, it's also important to note that every employee that works for wages in Ontario has an employment contract. Many employees will say, no, I don't have a contract. And what they mean is that we don't have a written contract. But if you're working for wages and receiving wages, you do have a contract. It's governed by oral or implied terms and by the minimum standards in the Employment Standards Act. And so oral contracts are good contracts. They're just sometimes harder to prove because you don't have in writing and you don't have the certainty of having it in writing. So that issue goes back to if you've got an employee who's laid off and they don't object to the layoff, that employee may be seen as acquiescing to the change in their employment situation. So now that the employee has been laid off, technically they couldn't because it wasn't part of their employment contract. They had never been laid off before, but you've laid them off now. And so that may be seen as acquiescence. And so they may say that, there's an argument there that that employee has agreed to layoffs as a term of their employment because they were laid off before, but they haven't challenged it. It's really difficult to say how the courts will interpret that type of situation. If I was the employee, I would come back and say, well, no, it was a emergency, a pandemic. It was an unprecedented situation. I was only agreeing to that, the one layoff in the situation, right? I'm not agreeing to subsequent layoffs. It would technically be incumbent on the employee to say that, but again, practically speaking, that's probably not going to happen. So to answer your question, yes, you could try and lay the employee off subsequently, but if it wasn't related to any drop in revenue or COVID-19, you may have an argument that there's a constructive dismissal there. And even if it is related to a drop in revenue, they may argue, okay, well, it's a constructive dismissal. And bear in mind, you've got the test for a temporary layoff. The baseline is 13 weeks in a 20-week block, right? So as soon as you exhaust the amount of time that you can have a temporary layoff, that's going to be deemed a termination, and it's going to result in the obligation to give notice of termination or termination pay.
Okay, so we have another question. If a business claims to be essential, are all employees required to show up for the work?
Well, certainly they are. Yeah, if it's an essential business and the employer asks them to come to work, unless they have a valid reason for not attending work, then yeah, they would have an obligation to show up and work, right? Again, there are a number of valid reasons for not attending work. It would probably be advisable to give employees who say they're anxious about COVID-19, perhaps more so, maybe they're the outlier and they're more anxious than the other 19 employees in a group of 20, it may be advisable just to give them some leeway and say, okay, if you're really that concerned about it, let's agree that, you can be off. Again, they may formally exercise their right to be off through a medical leave or a declared emergency leave. Frankly, and I don't want to make any sweeping statements, but when an employee goes to the doctor nowadays, the doctor issues a note, say, employee to be off work for X amount of time, and it says nothing else. So it's frankly, very simple for an employee to go to their doctor and say, listen, I don't want to go to work. The doctor will say, okay, here's your medical note to be off. And, I can't comment on how that conversation happens specifically, but that is quite common that the employee will go say, I've got a lot of anxiety about going to work. That'll be sufficient for a doctor to give a note to say, I want to be off. But unless there's an authorized absence, if the business is open and it's their job to show up to work and they're not doing it, technically speaking, they would be breaching their obligations to show up for work. That's their side of the employment contract.
Okay, that's all the questions that we have so far, unless anyone wants to take a moment now. If you had additional questions, maybe something else has sparked an inquiry for you. There was also a question about whether or not we'd make the presentation available. Yes, we will do that, either through our website or we'll send it to you directly. I'll communicate with all the registrants via email as to where you can find the presentation. Is there any other questions that anyone has? We'll just give it a moment.
Yeah, take your time.
The questions thus far, Warren, do they seem to be in keeping with some of the inquiries that you've had thus far?
Yeah, and I think, again, I think it'll continue to evolve. My biggest, what I've noticed the most from this is that really it is unprecedented. It's requiring people to be creative and innovative in the way they do business. And I think it'll be good for businesses that way. Obviously, it's going to be a major challenge with decline in revenue and that sort of thing. But these are the types of questions that you have to ask. And, it goes back to being able to communicate with your employees. And importantly, what are the terms of your employment agreement? And like I said, many people don't have an employment agreement. It is helpful to have one in writing because of issues like this. It's difficult to say that, go back in hindsight and say, oh, we should have had a layoff clause in our employment contract. But, obviously that type of thing would be helpful in a situation like this. And it might be something to consider if you're hiring new employees, or if you want to talk about renegotiating an existing employment contract. That might be something to consider to include in the language that you'd be allowed to do that. Because if you contract for layoffs, then it's something that you're allowed to do. But historically, that's not something that non-union employees have done. You go to work, you expect to keep working until you decide to quit and take another job, or you want to retire, or the employer is not happy with you, or it can't continue to employ you, and then it terminates your employment with or without cause.
Excellent. I have no other questions, so I'd like to invite anyone that encounters any challenges moving forward with regards to this to contact you directly. at O'Neill Associates, and your contact information will be on the slides that we will share. Thank you so much, Warren, for our session today. We really appreciate the information that you have shared with us. And I'd like to thank everyone for participating.
Well
Thanks,
done.
Tara. Appreciate the opportunity.
Have a wonderful afternoon. Thank you.
It was excellent. Very, very informative. Thanks so much.
Great, appreciate that. Thank you.